My name is Gassia Apkarian, and my name has been thrown around several times this morning. People are thanking me. I want to say that I am just an advisor to the Center for Truth and Justice. I'm a sitting judge in the state of California. I'm a trial judge. I'm a criminal judge. Um, and one of the things that occurs to me every time I sit, we're picking a jury, because the very bad felony cases are tried in my courtroom. The one thing that I think is defendants that are in my courtroom are actually getting their day in court, and they're getting an opportunity to be heard. And the reason the Center for Truth and Justice was created by the collaboration of over 30 volunteer lawyers, mostly diasporan lawyers, and then volunteers in Armenia and in Artsakh, some of the students from which you heard today, is because we feel very strongly about giving our people, victims of war crimes, the opportunity to be heard as well. That's the purpose of this conference. It's the purpose of why Center for Truth and Justice came to be. And that is why we train young law students in Artsakh and in Armenia to carry on not the tradition, but the institution of documenting the truth, which comes from victims and witnesses of war crimes. Not the truth according to a government or according to politics or according to those who are rewriting history, but the truth based on what victims and witnesses experience. So what I want to do is actually thank all the volunteers that have made Center for Truth and Justice a reality. That includes Emilia, the chairperson of this conference, who's worked effortlessly. It includes everybody you've heard from today: Arame, Arsine, Emilia, Misha, Anush. There are many people, they're not here, so I can just name whatever I want. But so I just wanted to take a minute and express my gratitude to an amazing organization. However, without further ado, Mr. Crane is joining us today remotely. I'd like to introduce him. David Crane was the first chief prosecutor of the Special Court for Sierra Leone, a hybrid internationalized tribunal created by the United Nations to prosecute war crime and crimes against humanity committed in the context of the Sierra Leone Civil War. As chief prosecutor of the world's first hybrid war crimes tribunal, he spearheaded landmark prosecutions, including that of Liberian President Charles Taylor, the first sitting African head of state to be prosecuted for crimes against humanity. He recently published a book on his experiences at the Special Court titled "Every Living Thing," the first such account by an international chief prosecutor. Prior to his time at the Special Court, he served for 30 years in the U.S. federal government in a variety of capacities, including as a member of the Judge Advocates General Corp and as director of the Office of Intelligence Review in the Department of Defense. Since leaving the Special Court for Sierra Leone, he's played a leading role in the Syrian Accountability Project and in advocating for the creation of the international, imperial, and independent mechanisms for Syria. He founded the Global Accountability Network, which in addition to the Syrian Accountability Project, houses the Yemeni, Venezuela, Uighur, and Ukrainian Accountability Project. Currently, Dr. Crane is assisting the international community in the creation of a special tribunal for Ukraine on the crime of aggression. In 2014, Dr. Crane was the co-author of the world-famous Caesar Report, which captured for the first time direct evidence of crimes against humanity being committed by President Assad of Syria against his own citizens. Dr. Crane is a veteran, having served his country as an officer in the 101st Airborne Division during the Vietnam era and the 82nd Airborne Division, as well as Special Operations Officer in the United States Army. His highest awards include the Master Parachute Badge and the Legion of Merit. He holds various undergraduate, graduate, and professional degrees from Ohio University, Syracuse University, and Case Western University. He recently retired as a professor at Syracuse University College of Law, where he founded Impunity Watch, Dr. Crane currently is a distinguished scholar in residence at Syracuse University and an adjunct professor with the Washington College of Law of American University, where he teaches international criminal practice. Dr. Crane, the floor is yours.
Thank you, Judge, and good afternoon, I would guess, and welcome. And it's good to greet you from the Smoky Mountains of Western North Carolina. I want to thank the organizers of the Center for Truth and Justice, their second annual conference. My compliments to you all. You know, this is a very important topic, justice for victims of international crimes, atrocity crimes. And I think it's really important for us to fully understand, having been a practitioner, not an academic, but a practitioner for over 2 decades related to international criminal law. I'm one of the founders of modern international criminal law. One of the things that I have always reminded everyone, that the reason why we seek justice for victims of atrocity is about the victims. It's for and about the victims. And you know, the UN has a terrible tendency to step over the victims and go in and do something and leave. But at the end of the day, having lived and worked in West Africa among victims of atrocity, I fully understood that, in fact, victims are very, very important. And that's why we do atrocity accountability. You know, I would be with you today, but back in September of last year, Vladimir Putin declared me an enemy of the state and banned me from travel in the Russian Federation. And I was told that it was just too risky for me to be that close to the Russian Federation. But I'm glad to be able to talk to you today about some important things. And that is, you know, I think we need to put in context, having been doing this for over 2 decades as a practitioner, seeking justice for victims of atrocities. You know, I've come to realize that, you know, in the 21st century, our conflicts are what I would call dirty little wars, where combatants, be it non-international or international armed conflict, really don't follow the laws of armed conflict, international humanitarian law. And so the victims are civilians mainly. And so I want to comment on that because I think it's important for us to understand that and put it in context of today and the dirty little wars that are being fought in your region and elsewhere, and areas that I've been investigating for over 10 years. But let's put all of this, I think, in history, historical. You know, we're just leaving what I call the bloody 20th century, where over 200 million human beings died of unnatural causes. And from my research, between 110 to 125 million human beings died at the hands of their own governments. And it was a terrible, terrible century, the beginning of which we started the concept of holding individuals accountable for atrocity. But really, atrocity accountability is a recent phenomenon, one which is important and has to be done. But in the 20th century, there was not a lot of accountability, particularly heads of state who fed on their own citizens. In the middle of this bloody 20th century, as I call it, we saw some bright and shining moments. Between 1945 and 1949, we see the creation of international military tribunals, both at Nuremberg and Tokyo, and thus began the cornerstone of jurisprudence, of which, as a chief prosecutor myself, we used to hold heads of state accountable in the modern era. We also see the United Nations Charter creating, where the world came together and declared that we will settle our disputes peacefully and only use force as a last resort. We also see, and I think this is very, very important for our discussion, and that is the Universal Declaration of Human Rights in 1948. And it's a very short declaration, but an important one of which we've used to create jurisprudence to hold individuals who are committing atrocity crimes. And what the Universal Declaration of Human Rights really declares, for the first time in history, is that a human being legally has a right to exist. And you know, from that very, very trite phrase comes and allows us to develop crimes by which we were able to prosecute starting in Yugoslavia through Rwanda, Sierra Leone. Over a period of a century, but the Geneva Conventions of 1949 are protective conventions seeking to protect those found on the battlefield, such as the wounded and sick, prisoners of war, and civilians. Now, focusing on accountability, which is what we're here to do today, tomorrow, and Friday, I call them waves of accountability from an historical as well as a practical point of view. You know, the first wave of atrocity accountability was at Nuremberg and Tokyo, where the world began to flex the ideas and thoughts of taking those who feed on their own citizens, commit atrocity crimes, and use the law as a way by which we can control those who commit these atrocity crimes. So that's the first wave with the international military tribunals. And then up through in the Cold War and into the 1990s, we see the second wave develop, and that is the wave of accountability, which we see the creation of really the major international tribunals in Yugoslavia, Rwanda, Sierra Leone, and we also see the creation of the world's first and only permanent international criminal court, the International Criminal Court itself, stemming from the Rome Statute in 1998. So I call that the age of accountability. And the third wave, a wave which I never saw coming, to be quite frank with you, around 2015, for many, many geopolitical reasons, the world began to look inward and step away from the idea of international accountability. And we see the rise of nationalism and populism, and dictators and strongmen from around the world stepping forward, flexing their geopolitical muscle. And so we see a waning of atrocity accountability and the international approach doing that. It just also, by coincidence, the major tribunals in Yugoslavia, Rwanda, and Sierra Leone had finished their work. And so the only standing international tribunal was obviously our permanent one in The Hague, the International Criminal Court, which had its challenges. And we see just all of a sudden all the hard work that we've been doing for the past 20 years, we see it starting to unravel a bit. But then in some ways, and I think this is really important, we see a resurgence, and I'll talk a little bit more about that, a resurgence of interest in the international approach to atrocity accountability. But throughout all of this, end of the 20th century and into the 21st century, you know, we see these dirty little wars, wars that we see in Syria, Yemen, Venezuela, Nagorno-Karabakh, and elsewhere, where there is very little to no accountability related to the atrocities that are being committed both domestically and internationally. Frankly, they're not following international conventions. And really, at the end of the day, you have to understand that in accountability, we have this, we have to understand that the bright red thread of atrocity accountability is politics. It's a political decision to decide to hold individuals accountable for international crimes and to create tribunals and courts. Now, we knew, like I said, we do have this new wave, and this new wave today is when we see the invasion of Ukraine by the Russian Federation. And the world turned and looked around saying, well, how do we deal with this? Are we going to use force only, or are we going to use the law to control the situation and hold individuals accountable? And so we have a new wave of accountability that began last year in February of 2022. Now, of course, with the invasion of Ukraine, we see incredible violations of international law, all of them, war crimes, crimes against humanity, even genocide. And of course, for the first time, we are very much looking at the crime of aggression. But the key here is that the world has decided to use the law as a cornerstone to stability. And so the ICC has begun its work as it was designed to do, and importantly, last month held Vladimir Putin accountable by indicting him for war crimes and crimes against humanity. Now, that indictment is just the beginning. That indictment will be amended, and he'll be held accountable for many, many crimes by which he is the head of state and of which does not apply to international crimes. So the International Criminal Court will continue its investigation. But also, we're dealing with the accountability. We're also developing and creating, it's put together, the package is put together, and that is the Special Tribunal for Ukraine on the crime of aggression. And we are looking to see that created towards the end of this year. And that's really very, very important. And he has to be held accountable for aggression because, again, this is an attack on not just Ukraine, but the whole concept of the United Nations paradigm of settling our disputes peacefully and only using force as a last resort. So I will conclude my brief remarks today is that really at the end of the day, as I have been working in this area for many, many, many years, I have found, and I truly believe this, and we've shown this with the takedown of the world's first sitting head of state, President Charles Taylor of Liberia, that the rule of law is more powerful than the rule of the gun. Thank you for allowing me to comment.
Please stand by because I'm going to be introducing the other speakers. We have questions coming up, Dr. Crane. Thank you. I have the honor of introducing our next speaker, which is Virginie Amato, is head of advocacy and program at the Coalition for International Criminal Court, CICC, based in Brussels, Belgium. The Coalition for the ICC is the world's largest partnership advancing the cause of international justice. With member organizations across the world, the coalition is leading the global fight, the global fight to end Rome Statute crimes through a commitment to the core values of human rights and justice. The coalition works to promote a fair, effective, independent, and universal ICC and accountability and redress for the victims of such crimes through the Rome Statute system. Virginie is responsible for spearheading the CICC's advocacy and strategy development and implementation of activities and works closely with CICC members, including in countries in which the ICC is undertaking preliminary examinations or investigations. In her previous position, she focused on the greater European region and the European Union, including the South Caucasus, Ukraine, and others, and the workings of the Rome Statute system through the European lens. Ms. Virginie holds a master's degree in international and European law, focusing on international criminal and humanitarian law, and a law degree from Aix-Marseille Paul Cézanne University in France, and the Université de Gilles Studi de Milano Bicocca. I got it right or wrong? I have no idea. But it's in Italy. Ms. Virginie speaks French, English, Spanish, Italian, and some Russian. By the time you leave the conference, some Armenian. Go ahead, the floor is yours. Thank you.
Thank you very much. Challenge accepted. Let's talk on Friday. Thank you very much for inviting me to take part to this conference and join you in Yerevan. Indeed, the coalition is the largest civil society network aimed at advancing the global fight against impunity for serious international crimes at the national level and at the ICC. We're not part of the International Criminal Court, and we work to promote a fair, effective, and independent and universal International Criminal Court, effective national proceedings, and redress for the victims through the broader Rome Statute system of international justice. The coalition was actually created before the ICC itself. It led the civil society movement for the creation of the court back in 1995, and first launched a campaign calling for worldwide ratification of the Rome Statute as early as 1999 to get the 60 ratifications necessary for the court to be set up in 2002, a lot earlier than most were expecting. We follow and monitor most every aspect of the court's work and of its states parties, including to promote its independence, respect of its decisions, and integrity of its statute. We serve as a platform for our member organizations to engage with the court itself. For example, we hold annual roundtables with the ICC, but also engagement with the states parties and other key decision makers. As some speakers said also this morning, the essence of the international justice system is that states have the primary responsibility to prosecute and punish the perpetrators and provide redress to the victims. The ICC is not a substitute for domestic courts, but a court of last resort. The functioning of the court is based on the principle of complementarity, that the court will only intervene in situations where states themselves are either unwilling or unable to genuinely investigate and prosecute individual perpetrators of from statute crimes. Someone said earlier, and I think several of you, that the ICC will not solve all of a problem in a country or a region. Indeed, the court is part of what we call an ecosystem of international justice, in the Rome Statute system of international justice with other tools and options for accountability. And indeed, the expanded conflict and invasion in Ukraine last year has triggered a strong response from the international community, including through unprecedented support for a variety of justice initiatives to pursue accountability for international crimes. The range of initiatives demonstrates just how interconnected the different elements and dimensions are in that system. Yet, in too many places with a culture of impunity, victims are left with limited options. And despite the challenges and sometimes disappointments, slow progress in some cases, often the ICC remains the last hope for many victims around the world, and there is still a high demand for justice and redress. The court is not perfect, and it can do and should do better to serve the purpose it was set for, and civil society has a key role to play in that regard. To this day, it is remarkable that 123 countries have joined the ICC, voluntarily becoming part to its founding treaty. We believe that in order for the court to succeed and to reduce the impunity gap, an increasing majority of the world's nations must support the court, and this has remained one of our key goals since our creation. The coalition has advocated for Armenia's ratification of the Rome Statute since it signed the statute back in 1999, including more recently around the reform of the Constitution in 2014 and 15. We have welcomed the Constitutional Court decision issued in March that the Rome Statute is in line with the Constitution, thus allowing Armenia to become possibly the next state to join the ICC. We hope the government will submit the draft law for prompt parliamentary approval. This year is also quite symbolic as we commemorate the 25th anniversary of the adoption of the Rome Statute. There will be an event in particular in New York on 17 July that will include a treaty ceremony for the deposit of instruments of ratification of the Rome Statute. In all of this, civil society remains engaged and has a key role to play. We heard earlier that there's still misunderstanding about the ICC, what it does not, and what victims can expect from the court. Civil society has a key role to play to raise awareness about the court, debunk any misinformation, be it among the authorities, parliamentarians, general public, as well as in the media. So I would like to highlight a few of the reasons why we believe joining the ICC is beneficial and what messages could be used to advance this. First of all, it is important to remember that the ICC was created thanks to small and medium-sized nations to rely on the protection of international law. The level of support and recognition on the role of the ICC, in particular over the past few months, confirms that it is central in the international community's efforts towards accountability and a culture of deterrence. By joining the ICC, Armenia could provide a contribution to the joint efforts of hundreds of other states to ensure international peace, the protection of human rights, and show a clear commitment to the rule of law and create a culture of deterrence and accountability in the region. Ratification of the Rome Statute is also a powerful foreign policy commitment, including at the UN, at the EU, and more broadly in the region. Ratification of the Rome Statute and its implementation in national legislation is also part of the EU agreement with Armenia and part of what is called the EU acquis, or the EU body of law. Second, being part of the Rome Statute system of international justice can help ensure justice for victims across the globe. The court is a victim-centered court. Victims of international crimes are the reasons the ICC exists and are its first constituency. ICC states parties have also established a trust fund for victims, an independent institution through which victims and their families and other affected communities can receive assistance and reparations, including restitution, compensation, and rehabilitation. At the same time, the Rome Statute sets one standard for all. No one is below or above the law. No immunity is a cornerstone of the Rome Statute system. No official capacity is relevant under the Rome Statute. All individuals can be brought to justice for grave international crimes. Thirdly, joining the Rome Statute can also equip national authorities with tools to strengthen their own criminal justice systems and legal frameworks to ensure the effective investigation and prosecution of international crimes. In order to fulfill their obligations under the Rome Statute, states parties must implement the treaty by enacting domestic legislation. The adoption of national legislation provides states, among others, with the opportunity to exercise domestic jurisdiction over core international crimes. In addition, the domestication of international standards can help strengthen the domestic justice system and respect for human rights and rule of law more generally. Moreover, with full ratification of the Rome Statute, states are able to exert full rights of membership in its assembly, the court's management, oversight, and legislative body composed of representatives of the states that have ratified or acceded to the Rome Statute. The Assembly discusses and takes decisions on a large number of issues central to the functioning and success of the court. It works to improve the efficiency and effectiveness of international justice and also elects officials to the ICC, including the prosecutor and its judges. It is a very important forum for all states and civil society. Civil society and my network, the coalition, has an observer status in this assembly, and civil society attends in large numbers many of the meetings of the states parties and its annual session. I know that my co-panelist will speak more of the Rome Statute ad hoc declaration that some referred to this morning, whereby a state accepts the jurisdiction of the ICC, what is called the 12.3 declaration, referring to the Rome Statute provision. A state that accepts the jurisdiction of the court with the 12.3 declaration does not become a member of the Assembly and does not enjoy the same privileges I just mentioned. Yet it has similar duties and obligations as a state party, including to cooperate with the court as per Part 9 of the treaty. I think I will stop here. I did want to make a point on cooperation that was discussed earlier, but perhaps I will keep that for the discussion. So I will just end by saying that now that the government of Armenia has expressed willingness to join the ICC and taken important steps to that aim, we hope to be able to welcome Armenia in the Rome Statute system very soon. We look forward to working with civil society organizations and authorities and parliamentarians to make that happen. Thank you very much.
Mr. Larochelle is the founder of Larochelle Avocats in Montreal, Quebec. He represents clients in both civil and criminal matters before Canadian and international courts. Law is an art that he learned to practice in the most varied context, from the Supreme Court of Canada to the Appeals Chamber of the International Criminal Tribunal for Rwanda, from the Superior Court of Quebec to the International Criminal Courts. Mr. Larochelle, welcome back.
Thank you very much for having me back here and allowing my two daughters here, Irene and Adele, trying to hide there in the audience as further victims of my conference this year. So it's always a joy to come back and to discuss with you and with the organizers of that conference, trying to put our legal mind to finding novel and creative solutions to a very difficult situation. I remember last year we spoke about examining remedies in Canada against the manufacturers of weapons that were used in the Nagorno-Karabakh war. This year I was asked to talk about the ICC and more specifically about Article 12.3 of the Rome Statute. We heard Madame D'Amato giving all of the advantages of marrying with the ICC and taking the big step and going full on in embracing the Rome Statute, whereas some people might advocate to be more prudent and to take smaller steps, or maybe to sign some sort of a prenup before you engage into that significant relationship. And surprisingly, or maybe not, the Rome Statute allows for an exercise of the sort. And Article 12.3 allows a state, short of formally ratifying the Rome Statute and being bound by all the obligations of the Rome Statute, to make an ad hoc declaration and to accept the jurisdiction of the court on a more limited basis, or to try maybe to limit the jurisdiction of the court to a situation or to a certain period. So I will talk of 6 principles surrounding declarations of Article 12.3 of the Rome Statutes. The first principle is the types of declarations. So declarations under Article 12.3 can be made by non-state party to accept the jurisdiction of the court on an ad hoc basis. That's the first type of declaration, and that's the one that I will talk about today, because I think it's more of interest for Armenia. There's a second type of declaration which allows state parties to make a declaration to cover a period that maybe precedes the moment where it acceded to the Rome Statute, so to give temporal jurisdiction to the court before it acceded to the Rome Statute. The second important principle is that a 12.3 declaration is not a referral by a state party. So the declaration does not by itself constitute a referral or activate proceedings. It simply broadens the potential scope of the jurisdiction of the court. That's the second principle. The third principle is that when a state lodges a declaration under Article 12.3 of the Rome Statute, they cannot limit the jurisdiction of the court to certain crimes only. They can stipulate a situation, they can stipulate a period, but this remains subject to confirmation by the prosecution and the chamber. The fourth principle is that of retroactivity. The declaration under Article 12.3 can have both a retroactive or a prospective application. And of course, that cannot go before July 1st, 2002, when the Rome Statute came into effect, but it can go as far as that date, depending on the state's wish, the state that makes the declaration. The procedure to make a declaration, there's no formal procedure under the Rome Statute to make a declaration under 12.2. The filing does not automatically trigger the exercise of jurisdiction, but as a matter of policy, and we'll quote to that specific provision later, the OTP then opens a preliminary examination following that declaration. And the sixth principle is that a state which makes a declaration under Article 12.3, as Virginie outlined earlier on, is then obliged to cooperate with the court. But there's no precedent so far of impacts or consequences for states who made such declaration who failed to cooperate with the court in any manner whatsoever. And in terms of precedents, there has been 5 states who have lodged declarations with the court so far. There's Ivory Coast, there's Uganda, there's Palestine, there's Ukraine, and there's Egypt. So I'll come back to each of these states to give you more details about the circumstances surrounding the respective declarations to the court under Article 12.3. So I said I would focus on the first type of declaration, that which would be made by a non-state party such as Armenia. That declaration would then extend the personal, temporal, and territorial scope of the jurisdiction of the ICC to criminal conduct committed on the territory of a non-state party, over which the court would otherwise lack jurisdiction under Article 12.2. So that declaration would then allow the ICC to exercise its jurisdiction over a non-state party. So Armenia could make a declaration under Article 12.3 to ask for certain periods or certain parts of its territory to be covered by that declaration and to ask for the ICC to investigate what is part of the declaration. I'll try to go faster because I realize I will run out of time. I'm not going to dwell on the second type of declaration. As I said, I must insist that the declaration is not a referral. So it does not automatically trigger the exercise of the court jurisdiction. That's important to keep in mind. The prosecutor still has to open a preliminary situation and ask for the permission to investigate, but it would allow for the situation in Armenia, and we will talk also about the fact that a declaration under 12.3 could cover Armenian citizens. So to the extent, for example, that there are allegations that Armenian citizens committed war crimes in Nagorno-Karabakh, then that would confer jurisdiction at the ICC to investigate those crimes, even if that territory is not formally part of Armenia. Then there would be an avenue for investigations to take place in Nagorno-Karabakh. I think this is an interesting possible strategy. I don't know to what extent the authorities of Armenia would be willing to go down that path, but formally, under the text of the Rome Statute, there is nothing then that would prohibit, except maybe the will of Azerbaijan, from the ICC investigators to go into Nagorno-Karabakh and investigate these allegations that are made by Azerbaijan against Armenia and against its citizens. So a declaration by Armenia under 12.3 could open up a way to at least have some ICC presence in that territory, to have, worst case scenario, Azerbaijan would blockade the road or not allow investigators, which I think would have the impact at least of undermining whatever allegations they want to maintain about the conduct of Armenia during that conflict. As I said, there's an important precedent in the Gbagbo case, because the Gbagbo case was possible at the ICC following a declaration by Ivory Coast. The reason is that the crimes allegedly committed by Gbagbo were committed before the ratification by Ivory Coast of the Rome Statute, so the Ivory Coast had to complement, so to speak, its ratification by a declaration which was covering the period during which the crimes alleged against Gbagbo were committed. I'm not getting back on the retroactivity issue. It is possible to go back in time, and to go back in time as far away as 1st of July 2002. So there is therefore a possibility that for Armenia to include past conflicts and past, both in the Armenian territory and outside of the Armenian territory, as I mentioned earlier, if you want to extend that jurisdiction to Armenian citizens, and to then seek the assistance of the prosecutor to investigate crimes allegedly committed by its citizens. There's not been a declaration so far specifically about a request or by a state to investigate its own citizen. I think the situation is quite unique. The situation we're dealing with here is quite unique in that Armenia could not possibly go into the territory of Nagorno-Karabakh to investigate, which makes the complementarity of the ICC an interesting avenue here. So I don't know whether there's been any thoughts or discussion within the Armenian authorities to go down that path, but I think thought should be given to the idea. As I said earlier. The worst case scenario is for the ICC to be blocked or not to be allowed on the territory. Best case scenario is for the ICC to have a presence there, maybe to have a positive impact on that blockade which prohibits access to the territory. So, and you know, after 1 year of looking at the situation and seeing still in you know, a blockade and a standstill and accountability and investigations not really moving forward and being blocked at every turn on the way, that may be something that could steer things up and allow for some things to happen. Precedents. The procedure, as I said, there is no specific procedure to file a declaration under Article 12.3 of the Rome Statute. The prosecutor, in his policy paper of 2013 at Article 76, makes it a matter of policy that says the following: upon receipt of a referral of a declaration pursuant to Article 12.3, the office will open a preliminary examination of the situation at hand. So that's a first step. The prosecutor will start working on the issue described or denounced in the declaration. Past examples of declaration under 12.3. I mentioned Ivory Coast. Ivory Coast used the declaration in the second type of scenario, which I alluded to earlier on, which was basically to retroactively confer jurisdiction to the International Criminal Court. The second state was Uganda. Uganda was a similar scenario. The situation, they ratified the ratification on the 14th of June 2002, and that entered into effect on the 1st of September 2002, but they needed to go back to June 2002 to cover the crimes committed by the persons which were mentioned in the war stories related to the Lord's Resistance Army. Palestine made two declarations. The first one in January 2009. You might have followed all the procedure about whether Palestine was a state or not. This was decided in April 2012 when the prosecutor issued a statement concluding that Palestine was not a state. So that was the first attempt to make a declaration. Then they came back, Palestine came back on the 1st of January 2015. Then on the 2nd of January 2015, Palestine acceded to the Rome Statute by depositing its instrument of accession with the UN Secretary General. And following that, on 16th of January 2015, the prosecutor announced the opening of a preliminary examination into the situation in the state of Palestine. And in March 2021, the prosecutor announced the opening of an investigation. And then the pretrial chamber, that followed the decision of the pretrial chamber on the 5th of February 2021, allowing the court to exercise its criminal jurisdiction in the situation. By a majority, it was not a unanimous decision. And that another example is Ukraine. Ukraine is doing just that. It has filed two declarations under Article 12.3, so it is not formally, it has not formally ratified the Rome Statute, yet, as you can see in the newspaper, the ICC is investigating and even issuing warrants of arrest against Putin. So it gets the benefit of the ICC and not some of the obligations that are associated with joining the Rome Statute. So it made two declarations. The first one limited to 21st of November 2013 to 22nd of February 2014, and a second declaration where it targeted all crimes committed in its territory since the 20th of February 2014. So it's prospective in nature, so it's open-ended and does not stop for now. And the last attempt was done by Egypt. An organization called the Center for Truth and the Freedom and Justice Party submitted a declaration to the registrar trying to have the ICC exercising its jurisdiction on the territory, but in the end, the registry treated that submission as a communication under Article 15 of the Rome Statute. So there was no suite to that declaration which was not made by the proper organs of the state. So in terms of pros and cons, and I will finish with that, the first advantage of proceeding by a declaration under Article 12.3 rather than a ratification of the Rome Statute is that you don't need to accede to the Rome Statute and all the obligations that are associated with it. So you get the deterrence benefit of the declaration. You get more accountability for the crimes committed on your territory and for the crimes committed by your nationals. You may, to some extent, work on defining the situation and defining, for example, its temporal scope. And you get, it might be done for a political reason or to get publicity on a situation such as the one we are discussing for the last year, where you want media attention and you want more outreach on in the international media. The cons is that you also lose control to some extent of the narrative. You cannot narrowly define the crimes. So to some extent, you give away the narrative to the prosecutor, and then the prosecutor decides what he wants to do with that situation. You lose judicial oversight also about the situation. You are under cooperation obligation with the court. You cannot and then you get the prosecutor to investigate on both sides of the crimes which are covered by the declaration. So I will stop here for now. I think I'm respected my 15 minutes allotment.
We don't want to cut you off, but we want people to have the opportunity to ask questions as well. We have a lot of questions here. Let me start with Dr. Crane. So one of the questions is this right of accountability. It seems to us, based on what we've heard, that there's plat du jour, the crime or the country of the period, right? Right now, it seems like all focus is on Ukraine. Other countries have been in a really bad shape criminally with regards to accountability and impunity. So obviously, with criminal accountability, ICC, ICJ, you name it, we like to believe that it's all about justice, but politics plays a big part of it, right? So the question is, a small country like Armenia, and then a small nation of 120,000 people who are under a blockade, where do these small nations fit in with this idea of impunity and accountability? Do not laugh. Does size matter? Is that what we're talking about? Ukraine is just bigger, or is Russia the foe of the period right now? So everyone's focused on that. So does that make sense, Dr. Crane?
Well, it does, and it's a real challenge, and it's a great question. And it is kind of the 400-pound gorilla in the room in some ways. As I hopefully clearly stated, the bright red thread of modern international criminal law is politics. We have the jurisprudence, we've got the experience, and the rules of procedure and evidence to deal with atrocity crimes. But that's not how the international community deals with atrocities and problems around the world, which you've alluded to. It's a political decision. If the international community or a regional organization is not interested in doing something about it, it isn't going to happen. I mean, as I talk to you this afternoon, China is committing genocide and has been committing genocide for years. And the international community doesn't have the political stomach to do anything about that. They're not going to take on China. In fact, frankly, let's just be honest about this. Nobody goes to war over a human rights violation. It just isn't going to happen. It has never happened. We go to war for many right or wrong reasons, but we don't take on a country for human rights violations. I'm just being brutally honest here. And so the reason why we're not doing anything, for example, in Syria is because there's no political will to do anything about it, or Yemen, or Venezuela. or what's going on in your region. The bottom line is that you have to have a political will, a political interest in doing something about that. And so we have to turn, frankly, there are some practical ways. It's going to have to be done domestically or regionally. Because again, I don't see any movement right now related to your region and dealing with some of the challenges you had over the past many years, actually, in Nagorno-Karabakh. So, it's an unanswerable question other than to state, based on my decades of work in this area, is that one of the important things that you have to do as someone who's been doing this a long time is you have to focus on the politics. You have to get the region or the international community politically interested in doing something about it. If they're not, it just won't happen. So, there it is. It is what it is. We do the best we can. Sometimes it's 2 steps forward, 3 steps back. But your question goes really right to the heart of the matter related to modern international criminal law, and that is the bright red thread is politics.
Well, Dr. Crane, I really appreciate the honesty, and I think honesty is what we all need to hear. And the list of countries that you just listed that the international community does not have the stomach to do anything about the crimes that they're committing, you can just add Azerbaijan to it. Would you agree with that?
I agree. Yeah, it's one of those situations where if there's an interest, there's an interest. Of course, obviously, the invasion of the Russian Federation into Ukraine is truly significant, only because of the idea of it. We have a permanent member of the UN Security Council, the operative arm of the United Nations, invading the sovereign territory of another member state of the United Nations. It's a slap in the face of the idea of the United Nations. If the United Nations does nothing about this, then it's going to be a very dark rest of the century, because again, the rest of the world's strongmen are watching all of this like crocodiles. I think we've started in the right direction by indicting President Putin as a war criminal, which is a lifetime imperator. I mean, he is now an indicted war criminal. There is no statute of limitations. And so, he's going to be limited in his travel. He's lost all his legitimacy politically. He is not an honored member of the community of nations anymore. Who would have thought that the Russian Federation now is a rogue state on the same level as, for example, North Korea? This is a real geopolitical challenge. But I think we're moving in the right direction. We do have him indicted. And, the movement towards creating that special tribunal for Ukraine on the crime of aggression is moving forward. And I believe that politically, there will be a decision made in 2023. We have to do something about it, but I strayed a bit.
Thank you. Thank you for the honesty. Let's expand that list of pariahs internationally. Uh, Ms. Virginie Amato, we have a question for you. One of the things you talked about is the coalition works at the national level. Is that one of the things you brought up? Could you explain to us better what that means in the context of Armenia, to be specific? How would that work out? How does it effectively work at the national level?
Yes. Sorry. Thanks for the question. So as I mentioned earlier, the coalition is a network of civil society organizations of all sizes, local, national, regional, and international NGOs, coming together to fight impunity for international crimes. Our network as a whole does not takes position on key issues that impact the international justice system, but as a coalition, we do not take a position on specific investigations or cases before the court, or, for example, candidates to elections at the ICC. What we do is we serve as a resource for our member organizations to connect together from Armenia to another country that has maybe had the same experience, or with colleagues working on documentation, litigation before national or international courts. We also serve as a platform for our members, including possibly in Armenia, to have a dialogue with the ICC organs, including the Office of the Prosecutor, as well as states that are party to the Rome Statute and other states or international decision makers or the European Union, including the European Union, for example, to share their own views and concerns. The coalition, I'm work for the secretariat of the coalition. The coalition is the amount of its members in 150 countries around the world. We have a few in Armenia as well, and we've been working with some of them in the past years to, in particular, call for the ratification of the Rome Statute by Armenia. We have other types of support that we provide to our members, including capacity building, and also, as I mentioned earlier, networking opportunities with other civil society organizations around the world. I hope that
You'll show us where the application is for CFTJ, right?
Yes.
All right. Mr. Larochelle, do you believe, there's a question here, I'll rephrase it. Do you believe Artsakh is similar in standing to Palestine with regards to the ICC, or I guess whether it's under the 12.3 status or membership? Basically, an unrecognized state concept, I guess.
No, I don't think Artsakh is in the same footing as Palestine for the purpose of acceding to the Rome Statute, for example. I don't think it could make such a, or I don't know that it would be, I think it's formally, I mean, not completely familiar with the international situation of Artsakh. I think it's considered by most states as being part of Azerbaijan.
Correct.
So I don't think that a declaration or a ratification, a declaration by Artsakh or a ratification of the ICC by Artsakh would be considered or accepted, but you never know. It should be tried. First, you need a political will by the authorities there, and whether they might think that there might be trouble with that, or that it might be followed by some repression by Azerbaijan. So, but I don't think it would be treated it could be treated in the same manner as a ratification or declaration by Palestine.
But you stated earlier, right? Citizens of Armenians can be protected through Armenia.
Can be what I was looking at. I was examining the possibility of making a declaration. I was looking at every possible angle of this problem, where because of this Artsakh thing that is, populated by Armenians, yet formerly part of Azerbaijan, which creates all sorts of difficulties, and for Armenia as well, all sorts of difficulties on the international plane. And I was thinking that, inquired with friends, and I hear that Azerbaijan is making claims that Armenians committed war crimes and crimes falling under the jurisdiction of the ICC during the conflict over there, so that if that is the case, then an interesting avenue to explore would be for Armenia to make a declaration covering crimes committed by its citizens in Artsakh during the conflict there, which would trigger normally the jurisdiction of the ICC, because the jurisdiction cover both the territory and the nationals of a state, and could cover the nationals of a state making the declaration under 12.3, which would then put the prosecutor in a situation where it would need to respond to that declaration by launching an investigation into that. So what can happen from there? They can be blocked, which more or less puts an end to the matter, but also undermines any allegation and puts Azerbaijan more into the villain corner, so to speak. Or otherwise, you may have Azerbaijan granting access to it and not blocking it, in which case you have ICC investigators on the ground, which is maybe not a bad thing, and investigating and talking and having this artificial division in their mind that they're only allowed to investigate crimes committed by Armenian nationals, but not those committed by Azeri ones, which illustrates this what we were talking earlier, the fact that the situation there is maybe too much under the radar, and it's absurd. It would create an absurdity to have a situation where they would be allowed to investigate crimes in a region, but because of the fact that Azerbaijan is not willing to participate in the Statute of Rome scheme, only investigate Armenian. Again, we're making scenarios and we're throwing hypotheses right here. I don't know how that would unfold, but I'm just trying to shake things and find the way out of the situation.
There's an interesting question for David Crane. Bear with me. It's interesting. I'm going to read it. It says, you are the first person expert to accurately predict the issuance of the arrest warrant for Vladimir Putin. Did you actually predict this before it happened?
Actually, I did. And
establish
again,
that as
it's
a
just
foundation.
that.
Okay, let me ask the question. I just wanted to make sure that foundationally that was true, because I didn't know you had predicted this. Maybe we should ask you about some predictions on Azerbaijan, and it might come true, so I don't know. It says, could you walk us through how you think the next steps will be to the eventual prosecution? Well, you know, if you have any ideas on this.
Well, again, is this the indictment and arrest warrant related to the movement of children into Russia, or is this as we begin to, and we have created, it's just a function now of the UN General Assembly politically referring it to the Secretary General related to the aggression tribunal and enter into a bilateral agreement with Ukraine. I'm not sure what it is. The next steps, as far as the ICC, they have the rules of procedure. You know, they're going to continue to move forward. You know, the prosecutor is investigating all of the allegations of international crimes, and there are many. I mean, Vladimir Putin, as commander-in-chief of the armed forces, is individually criminally liable for all of the actions of his armed forces, as if he committed the crime himself. So he's deeply liable, criminally liable, for many crimes, and the prosecutor will continue procedurally to investigate and amend the indictment against Putin. Now, it's also, as a footnote, it's important for us to realize that there are over 24 most responsible persons in this tragedy, this invasion by the Russian Federation against Ukraine. And so it's not just Putin, but it's his political as well as its military leadership as well, both for the war crimes, crimes against humanity, and potentially genocide. But also, as we develop a case against him on aggression, certainly aggression as well. So, you know, the procedure is follow the rules of procedure in any international criminal tribunal or court. And, you know, we've already put together the rules of procedure and evidence for the special tribunal as well. So we're, you know, again, the package is sitting there waiting for a political decision to move forward. Again, this is an aside. There are kind of three approaches to dealing with the aggression, and because it's the first time we've ever quite done it this way in the modern era, we have strong considerations of attacking as a hybrid tribunal with Ukraine. And then there's also a regional approach with the European Union dealing with the aggression. And then, of course, what my group is advocating and has put together is the United Nations, the international approach, which really, truly is starting to develop a momentum and really has to be done. So we have these, you know, these three approaches related to dealing with the aggression, but we do have to do it. And I think it's really important to understand is the world now has made the decision that we will account for the aggression. It's just a matter of what that's going to look like. So again, I'm not sure I answered the question, but you know, there it is.
You know, it's a prediction as best as you could make one, I guess. I think we're going to ask this one of Ms. Virginie Amato, and I'm going to paraphrase this question, and there's parts. So it says, The ICJ did make preliminary rulings as it relates to Azerbaijan, as you might be aware, in Armenia versus Azerbaijan. And they were quite specific. And the most recent one has to do with the blockading of the Armenians and the closing of the Lachin corridor, which basically said you must allow for free movement. So the question becomes, how will the ICC influence Azerbaijan and force them to follow their decisions without direct access to Karabakh? Well, I think we've discussed the access issue of, they might let you in, they might not let you out, and we'll find out, but you can only find out if you demand to go in. But the question, I think it has something to do with the people in Armenia and in Artsakh are frustrated because there has been a UN Security Council vote about the Lachin corridor that said open the corridor and allow for unimpeded movement. Subsequently, the ICJ came down with a preliminary order that said open the corridor and allow for unimpeded movement, and it's been completely disregarded. So the question becomes, will the ICC come through if Armenia joins one way or another, whether it's under 12.3 of article or full-fledged member?
Thanks for paraphrasing. I cannot imagine what was the original question, if it was easier or more difficult. No, sorry. So to be truly honest, we're not following closely the workings of the ICJ. I haven't read myself that ruling, but to take that to the ICC, first of all, in terms of generally, again, I do not work for the ICC, so I'm bringing the civil society perspective and the observer here. The Office of the Prosecutor does not always have access to territories where there is a situation or an investigation open. There's no secret about it. Including in, for example, in the Philippines or in Palestine, we just mentioned, and several others. So they have used other tools to be able to investigate and build cases. In terms of frustrations of related to impunity and perhaps lack of attention to certain situations, as we said before, the ICC is not the panacea. It will not solve all the issues or deal with all alleged crimes or human rights violations in a country or a region. We have to be honest about that. It brings a sense of hope and a sense of last resort. Why I think several of us today mention the issue of cooperation is because this is key for the court to be successful and execute its mandate. As I'm sure all of you know, the ICC has no police force or no enforcement body, so it really relies on the cooperation of states parties and other stakeholders to do its work, including to access territories, evidence, and to implement arrest warrants. So really the issue of cooperation is one of the most crucial ones and a big challenge for the ICC. Some of commentators of civil society have been frustrated by somehow lack of action in certain situations, and often it's linked to lack of political will, lack of support, including financial support to the court, but also lack of cooperation. There are about more than a dozen pending arrest warrants to this day, and that means that no trial can start, and victims cannot see alleged perpetrators in courts, or at least share their views and concerns during a trial, and potentially access reparations. So the issue of cooperation is really an important one, and a key for the court to be able to execute its mandate, on top of all the other challenges, but that's a very important one.
Anything? Mr. Larochelle, do you want to add anything to that?
I just want to agree with what Virginie is saying, that the ICC is not a panacea to all all international crimes and wrongs, we can see for ourselves how selective it is, how difficult it is to capture certain situations, certain countries. Most important states have not ratified it: the United States, Russia, China. The crimes committed by these countries are out of the realm of. Mr. Crane mentioned the Uyghur genocide, which is unfolding before our eyes, and we're talking a lot of a long period, and we're talking of the eradication of an important cultural and historical group there, with nothing happening really. We're searching containers arriving in Canada and the United States to see if it's made out of forced labor, but we can. So there's a Russian proverb that says, pray God, but keeps swimming towards the shore, which means, I think, to some extent, also Armenia has to also see what it can do here. Can it, for example, I know we've been discussing that, but there's been shelling on Armenian territory. Do we know the extent of the damages that was inflicted on Armenia by Azerbaijan as part of these shellings? Do we know how much money we're talking about? How much lost? How much lives lost because of that? We need that information. We need to take it first before maybe Armenian court, if it's possible. We need to look into where we can put dents into Azerbaijan. It's delivering gas everywhere in Europe. Can we go there and sue them? So, over the ICC and over these international court, which sometimes leave you with a bitter taste, there are national courts which are more and more active in the international forum and seeking, allowing. We discussed last year. There was a class action in Canada against the owner of a mine in Eritrea because of international crimes they were committing there. So it's worth also turning to national courts where sometimes they have more teeth and allow for more remedies in a situation such as this.
I agree. We need to swim towards the shore just as much. I'm going to close this up. Dr. Crane, thank you so much for joining us from afar. We guarantee your security if you decide to come next time.
Well, thank you so much. It's been a real pleasure, and I really enjoyed listening to the important comments of my fellow panelists. So I wish you all the best for a very successful conference, and my compliments.
Thank you. Any last words for our panelists in the room?
Well, just to, again, thanks, and congratulations to the other panelists, and thanks for the questions. I think they were really interesting, and looking forward to continue that discussion. You're missing out, Mr. Crane, on wine tasting and absolutely delicious. So I think it's even those are worth taking the risk.
That's
Forget
right.
The Russians.
I agree.
You should be here next time around.
Yes.
I wish I was there. Believe me.
Go ahead.
I just want to thank you as well very much. I know we are standing between everyone and the reception, so I will just say thank you and looking forward to continuing the discussion over the next 3 days.
Thank you. We'll see you guys tonight, and really the purpose of the conference is not just to have people sit up here and answer questions and give a 15-minute presentation. The purpose is to actually have the opportunity to go up to them, to talk to them, get to know them, and subsequent to their departure, continue working with them and reaching out to them. So thank you very much. We closed the first day.